Some people wonder what they can do when they are certain or even have an inkling that a divorce might be coming. What they can do to protect their money. What can they do to protect their assets from being distributed in the divorce in a way that they don't want? The answer is not much as far as marital assets are concerned, because the marital assets really do belong to the marriage. And while some people do try to get clever and hide them and not disclose them during the course of the marriage, that's a very dangerous tactic. Are some people successful with it? Maybe, but it's dangerous in as much as if you fail to disclose everything and are untruthful. First of all, you're doing a sworn financial statement, which means you're committing perjury, so you're putting yourself at criminal risk. But also, if you hide assets and don't fully disclose them, that divorce settlement or the final order and distribution of assets and debts can be overturned down the road. That can be reopened based on your lack of disclosure. So it's a very dangerous thing to do, and it could inhibit your feeling or ability to have closure once the divorce does in fact happen. This is not true, though, of non-marital or premarital assets that you've kept and maintained as separate property. And so I think it's important to think about what one should do before the marriage and what one should do and not do during the marriage to make sure that those don't get distributed in a way that you don't want them to. So a lot of people, when they come into a marriage, have assets from prior to the marriage. They might have an inheritance. They might have a house that they bought before the marriage. They might have a car that they owned before the marriage. They might have a retirement account that they owned before the marriage, and other things. And these are separate property. It's important, however, if you want to retain some control over how they get distributed or don't get distributed, then it's important to do the things to maintain them as separate property. It is really quite as simple as if they're in a separate account, if the inheritance assets are in a separate account, or retirement assets are in a retirement account, or the house is owned is titled in your name, or the car is titled in your name, or the horse is titled in your name, is just keep it that way, right? And keep it so that it's clearly identifiable as the asset that existed prior to the marriage. Now, the best and smartest way to do this, and this can include marital assets, of course, is to have a premarital or a marital agreement. Also, some people call them a prenup and a postnup. These can clearly define how the assets are distributed. But in the absence of those, keeping these accounts separate is very important. Where do people make mistakes? Well, by not keeping the accounts separate, right? So they might put the retirement account or the funds from the retirement account in a joint checking account, or even in a checking account opened in the name of the marriage can be dangerous if the other spouse also puts some funds in there. That's called commingling, and it can muddy up where the origin of the funds in that account is, especially if some money went in, some went out, some more went in, some more went out. You start losing clarity on whose assets went out and whose assets went in and whose assets are left in that account. Same thing with a house. I see some people will deed their other spouse onto the property. Very dangerous thing to do, because now this has become a marital property, or at least the half that you deeded to the spouse, but arguably both of you. Another thing that I've seen done to keep and maintain separate property is that sometimes during the course of a marriage, some separate property will be introduced by a third party. Parents, grandparents will give money as a down payment on a house, for instance. That's a common one. And this could be considered separate property if it's a gift to one spouse. However, it's often not clear as to whom it is a gift to, or it is given to the couple or written as a gift to the marriage or gift to the purchasers. And then this is a complete commingling of the funds, and they are now marital funds and no longer separate funds. So, in big picture context, if it's separate, keep it separate. If it's not separate, get a prenup. And if you're not sure of which way to go, a good family law attorney will be able to consult with you, an hour or 2 hour consult, where they can review your exact situation and give you specific advice that is pertinent to yours.